Good evening, good morning, good afternoon to everyone who's joined us today from India and around the world for this webinar on transparency in SEP licensing, patent pools, licensing negotiation groups, and the competition perspective. My name is Manveen Singh, and I head the Indian initiative for the George Washington Competition and Innovation Lab. And I have with me the privilege of the company which comprises of Mr. Eric Stasek, who's the director, Avica AB, Mr. Nishant Sharma from Dolby Technologies India, and Dr. Payal Malik, former head economics at the Competition Commission of India. Very warm welcome to all my esteemed panelists. The theme for the webinar today is largely going to revolve around a very important aspect of SEP licensing, that is transparency. Now, often neglected in the mainstream discussions involving SEP licensing, yet extremely important and central to the overall discussion surrounding SEP licensing is transparency. Because if we look at the various concerns that surround the licensing of standard essential patents, the lack of transparency has been at the center of attention, whether it be the recently withdrawn the European Draft SEP Regulation or the UKIPO's consultation on SEPs. In each of the instances, the focus of the agencies has been on bringing greater transparency to the disclosure and licensing aspect of standard essential patents. And one of the means by which greater transparency could be brought in is through the instrumentality of patent pools. And it is in that regard that I would like to open the discussion with Nishant. Nishant, given the importance attached to transparency in the draft regulation and the UKIPO consultation, how do you see the role of patent pools in addressing some of the concerns regarding the lack of transparency in SEP licensing? If I were to be more specific, I would say in the disclosure of SEPs and the determination of royalty rates, because in the larger scheme of things, it ultimately boils down to disclosure and licensing of SEPs. And that's the bone of contention between the SEP holders on one side and the implementers on the other. So how do the patent pools come into the picture when we talk about disclosure and licensing of SEPs?
Hi everyone. Thanks for inviting me for this webinar. A very good question, Manveen. Actually, I'd like to begin by sharing Dolby's experience of working with pools. We have been very, I would say, have had good success working with pools in licensing our technologies, our standardized technologies. And the core reason for that is because a pool offers a sort of one-stop shop, which is quite, I would say, quite advantageous for both the licensors as well as licensees. So it is something like an association or a consortium of licensors who come together to offer a license to the willing licensees, and anyone who wants a license can approach the pool and take a license without incurring much transactional costs in negotiating individual licenses with individual licensors for a particular technology. So coming to the aspect of how it is advantageous for the licensees. So most of the pools, as we have observed, publish their portfolio. So whatever you whatever is on offer, the patents on a particular technology are being offered for a license, are the list is generally published on the website. I'll just take an example of via AAC pool. You have a list of the patents there. Also, you get a list of licensees who have taken a license to that particular pool, uh, or to that particular technology. So you are aware that there are, say, thousands of licensees who have already taken up a license on this particular technologies, which also speaks of the frankness of the rates. It also establishes some sort of confidence in the essentiality aspect of the pool, the license, the patents that are included in the pool. Apart from that, the pools also publish the rates that are being offered on the license. So again, taking example of via pool, you would see the rates that are on offer to the licensees, and it's very transparent. So you know that if you are operating in one particular country, you may have a royalty. You may have to pay a royalty as per this particular rate, or if you have sale in, say, some developing economies, you may have to pay a lower rate as compared to the other economies. So in this manner, you get most of the information that you require to take a decision as to whether you should be taking a license or not. So in that sense, the information that is required by a licensee to take a well-informed decision for taking a license is already there, available in public domain. So yeah, so in that sense, I think it solves the problem of lack of transparency, which most licensees complain of in maybe bilateral negotiations. You have everything available to you at your own will. So you can refer to that and proceed with discussions in the very first moment that you want to. Yeah, so that's I would say about transparency.
Thank you. I think that's a very good starting point, of course, when we talk about how patent pools are, bringing in some sort of transparency, at least to begin with. Right. Eric, I'd next like to come to you because patent pools have been the focal point of discussion for a while now. It's not something which is new. You'd say if we go back to almost close to a decade now, patent pools had begun to show up in one way or the other. And of course, I know that you are very well, accustomed to how the patent pools function. And I would also want to hear your opinion about Avanci at some point a little later, and Kasim's efforts with respect to the same. But what I want to ask you at this point is the other side of patent pools, or the flip side of the coin, which apparently could be labeled as a licensing negotiation group. Because when we talk about a licensing negotiation group or an LNG, we are essentially talking about the implementers coming together and forming a group and then trying to collectively negotiate. So LNGs have fairly recently come into the limelight, although, yes, it's not entirely a new concept, but the term LNG is something that has caught the attention of late, of one and all. So, to begin with, what exactly is a licensing negotiation group? And how is it that the European Commission and the German Federal Cartel Office have kind of given the nod to the formation of an automotive LNG? So if you could throw some light on that.
Yeah, I'd be happy to. First, thank you for inviting me to join this webinar. It's a pleasure to be with such highly qualified experts talking about these things. Yeah, the license negotiation group is a new thing. I think I first saw the term in the report that was issued by the European Commission Standard SEP expert group, where they included as one of their recommendations for making licensing in IoT more efficient. And the thought was, I think, if you read through the expert group's report, the thought was they were thinking about small and medium-sized enterprises. A great example that I use all the time, I got from Roderick McConnell at Continental, is the manufacture of connected flower pots. This is not a sophisticated company. This is not a sophisticated product. They just want to add a little connectivity to it. And it should be easy for a manufacturer of flower pots to be able to add connectivity to their flower pots. But they're complete novices in this field. They don't know anything about standards. They don't know anything about IoT. They just want to be able to buy a component and put it on their pot. And the Commission recognized that most licensing takes place at the end user device level. So even though they buy this component and put it onto their flower pot, that flower pot manufacturer would still have to take a license. And from this scenario emerged the idea of a license negotiation group. Hey, wouldn't it be better if there was an association of connected flower pot manufacturers who could collectively negotiate, pull their resources together and collectively negotiate with these big sophisticated SEP holders to arrive at this transparency that Nishant just talked about. And that's where the idea started. And when I saw it the first time, I thought, well, that's a good idea. That probably makes sense. But then the Commission decided that the first license negotiation group that they were going to bless was for the automotive sector, which doesn't really fit the role of SMEs. And when I think of a Mercedes-Benz, I don't think of a connected flower pot. I think of a very sophisticated company with substantial resources that doesn't really need to work with others to negotiate their own licenses. But nonetheless, the Commission has given their blessing to this automotive license negotiation group. And I have to say, I'm not a competition lawyer, but I worked with SEPs for a long time, so I know a little bit about competition law. And what I see in the Commission's guidance level is the thinnest of guidance. Basically, the Commission said, well, we're going to look at the market not as the market for automotive connectivity, but the market for connectivity in general. And if we look at the market for connectivity in general, automotive is just a small percentage of it. It doesn't come up to the 15% level that would sort of set a threshold for concern in cartel-like behavior under your competition law. So we're just going to ignore that by saying that automotive, even though they completely dominate the sector that they're in, if we look at the sector as connectivity as a whole, smartphones, satellites, everything, automotive isn't more than 15% of that. So it doesn't give rise to any competition concerns, which I think is seems to me a very generous view from the Commission. The second thing they say, well, it's open to interested companies, not just automotive manufacturers. Their suppliers can also join the group. It's all voluntary, so there's no coercion involved. So that doesn't violate any competition law concerns. They say that negotiations with SEP holders are voluntary. SEP holders don't have to engage with the automotive license negotiation group, although in my mind it's difficult to see how they would avoid that if the ANLG insists on it. But they say it's voluntary. And then the last thing that the Commission said, well, as long as the members of this auto negotiation group don't exchange commercially sensitive information, profit margins, pricing, things like this that are classic red lines for cooperation between companies. As long as they don't do that, it should be this should be pro-competitive. So we're going to bless it. Again, I'm not a competition law guy, but I think that's the thinnest of guidance for something that's which appears to me to be a cartel of buyers. Why would the automotive companies, Daimler, Volkswagen, Porsche, Toyota, I mean some of the biggest companies in the world, why would they get together to collectively negotiate a license if it wasn't to drive the price down? What other efficiency could they hope to gain by doing this as a group? But that's where it is right now, and I know it's up and running as far as I know. I don't know if any negotiations have taken place, but the automotive sector is getting their act together to continue with this license negotiation group, and we'll just see where it goes.
Right. I mean, just an afterthought. I mean, we know now that the commission is looking at the prospect of LNGs, and they've given their blessing with respect to the formation of the ALNG. But do you see a difference in how their counterparts in the US would view LNGs? Because I know that Dina Kelly recently had something to say about the LNGs. So,
Yeah,
if I could just pick your mind for a minute on that.
the U.S. took a very absolutist view of this. This is cartel behavior, and there's no guidelines, there's no guardrails that make it safe for this kind of cartel behavior. That's sort of the U.S. approach right now. I think the U.S. is right about this. I think that makes, particularly with the automotive LNG, I don't see how a small handful of large, sophisticated companies, there's any efficiency for them to be gained by licensing as a group as opposed to individually. Sorry. And if I can just continue on that a little bit, I'm disappointed by this because I believe in the license negotiation group. I think there are efficiencies to be gained. Again, if I use the example of connected flower pots, no patent pool wants to go chase 1,000 manufacturers of connected flower pots all over the world, making a few thousand devices or a few tens of thousands of flower pots per year. Nobody wants to do it. There's no profitable way to license a market like that. It would be much more efficient from the patent owner's perspective, as well as from the licensee's perspective, to have these groups negotiate with each other and then sort of all their members to adapt that. I think there's great efficiency that can be gained by this, particularly within IoT, because we expect to have so many verticals in IoT that are going to be dominated by small and medium-sized companies making connected flower pots, connected clothing, connected everything. And so we can imagine most of those verticals are going to be small. They're going to be dominated by small companies. They're going to be dominated by companies that are new to wireless connectivity, new to SEPs. And so the idea makes a lot of sense for those kind of vectors or those kind of verticals. And the fact that the commission decides to begin in the vertical that least needs the help of a license negotiation group and also comprises just a few big, powerful companies, I don't see how they don't run into competition law problems with this. I don't see how this doesn't turn into a buyer's cartel. And I'm afraid that the guidance that is going to be necessary to keep the automakers behaving properly is not going to be the proper guidance that we would want to give to an SME, a group of SMEs. So I think that the concept is I believe in the concept. I think it's a good idea. We're just starting at the wrong end of the scale. And I think because we're starting at the wrong end of the scale, we're not going to get the guidance out of the competition authorities to make this work at the low end of the scale.
Yeah, I mean, that makes a lot of sense actually. And talking of competition, I think it'll be the right moment to get Dr. Malik involved at this point. I mean, I was just wondering, how does competition law, Dr. Malik, view the operation of patent pools and, let's say, perhaps LNGs in the entire context of SEP licensing? Are there any serious concerns surrounding the processes that are being followed at patent pools when they arrive at a certain rate? Because we are not looking at any kind of negotiations that the implementers or, let's say, the licensees could have vis-a-vis the patent pool license. The rates are fixed, they are written, it's according to them, it's absolutely transparent. It's a one-stop shop for everything that is to do with all those SEPs and the SEP holders patents involved who've contributed to the pool. So all the noise, if at all, about the transparency vis-a-vis patent pool licensing rates, is there some substance to it from a competition perspective, or is it just talk and no substance?
So, Manveen, thank you, and good to just focusing on a very, very narrow aspect of these discussions, because these issues are very, very nuanced, and we tend to, in large conferences, only talk on the periphery and don't get into the nitty-gritties of functioning of, say, of patent pools or of LNGs, etc. So thank you for having us in this webinar. So let's step back a little bit and try and understand why patent pools. So we'll try and distinguish, and Eric has tried to distinguish, though he says structurally they are the same, but in the how they are functioning in real life, there is a difference, and what is the problem they're trying to address. So if you step back a little and try to see what is the problem they try to address. So let's say in the case of patent pools, they're trying to address a problem of transparency, whereas in the case of LNGs, if I try to compare, they are also trying to address the problem of bargaining power imbalance. And so it will be a case by case. And so as Eric has mentioned, is there a bargaining power imbalance, at least in the comfort letter which has been issued by the European Commission and the ALNG? It doesn't seem so, because these are large automobile companies which on its own merit and on heft have sufficient bargaining power to negotiate a bilateral license. Because what these patent pools tend to do, in fact, patent pools, on the other hand, when we are looking at the problems associated with licensing, so patent pools are addressing more of the transparency issues. Yes, there is an issue of bargaining power imbalance in a bilateral negotiation, but I guess their function is more to deal with the transparency problems. So, for instance, we know that when the SSOs do require patent holders to commit to licensing on SEPs on FRAND terms, but these are loose price commitments in the sense they agree to FRAND terms, but what is FRAND, the interpretation of FRAND, etc., is all of us know here, often has led to litigation due to the ambiguity. And so, therefore, there is a post-standardization frictions do occur, and inclusion in a standard is not guaranteeing a frictionless licensing. So solution is, as you have mentioned, so if there is an asymmetric information problem, it's an information problem, and that information problem can be either addressed through a regulation or through a market-based solution. What patent pools tend to do is try to converge the incentive which diverge between the SEP holders and implementers, because they have misaligned incentives. SEP holders do possess more insights when it comes to validity and essentiality. But on the other hand, what is the value of that particular SEP to the follow-on innovator or to the downstream implementer is private information which the implementer has. Then, given the non-rival nature of SEPs, because multiple implementers can use the same SEPs without even diminishing its value. So, and there is a probabilistic nature of also whether or not a particular SEP is essential or valid. I guess pools then provide sufficient benefits, which there are problems also associated with pools. Pools are not just something which do not come with a baggage of some anti-competitive harm, but then we have to weigh the pros and cons and to do what is a rule of reason analysis when it comes to pools which are aggregating patents from multiple holders and providing with a single license with a collective royalty rate. So the key features, as we know, it creates transparency and certainty. The royalty allocation is distributed on patent value. And there's a broad adoption and can establish market-wide pricing norms. So it does deal with undoing or limiting the asymmetry of information. We all talk about Avanci. So Avanci right now is offering a $20 per vehicle license, and 80% of the automotive market is already bought into that pool and is accepting those rates. And I do remember a very heated conversation at the Warsaw conference where Sir Robin got up from the audience and he said, do you think $20 per vehicle license for the likes of Mercedes and the other large automobile companies, is it exploitative or extortionary? The answer is, of course, no. So the pro-competitive effects, we of course know there are efficiency gains. It reduces litigation and minimizes legal disputes, and it does save time and costs, especially and beneficial from the SME perspectives. So while large companies can get into bilateral negotiations, can get into very expensive litigations, etc., but there are huge transaction costs involved when it comes to SMEs. And so therefore, these patent pools are very important in reducing these transaction costs or lowering these transaction costs, because a single agreement will replace multiple bilateral negotiations. The competition concerns are twofold. One is that it may eliminate competition between substitutable technologies, because the patent pools is good at aggregating complementary technologies and giving it as a bundle because it is now to the user or the implementer. But when it comes to substitutable technology, there is some incentive of reduction in competition, because the substitute technologies will not then compete, because they would want to get into a aggregation of these patents, and it will reduce the competition between substitute technologies. So pooling of substitute patents may eliminate competition between technologies, which may raise antitrust concerns. And there could be certain pools, and I'm not saying Avanci is one, so let's just generally take pools, which may prohibit independent licensing. So independent licensing should still be allowed, and I know Avanci allows that. And at times, because I have heard people saying under their breath, and again, these conferences, that these pools are leading to supra-frand pricing. But all these are just anecdotal discussions. There is no solid empirical evidence to show that patent pools can lead to supra-frand pricing. In fact, while getting into this webinar, I just got hold of a very nice recent paper which has worked out the costs and benefits of and therefore the net effects of patent pools. And so, first of all, there is no doubt about the fact that there is savings on the transaction costs, because bilateral negotiations are very, very costly. And that paper basically suggests, it's a Ohio Law Journal paper, that pools do save hundreds and millions of dollars in transaction costs. Yes, there could be lost substitutes, as I have mentioned. So pools may suppress competition by combining patents on substitute technologies, potentially raising consumer prices. But then you have to, again, as I said, from a competition lens, you have to see it on a rule of reason basis, in the sense, do the pro-competitive benefits outweigh the anti-competitive harm? Then certain pools also have these, and Eric may or Nishant may want to elaborate on grant back clauses, where it requires members to license future patents into the pool, which therefore may deter innovation, because you will not give substitute patents into the pool. You will only give complementary patents into the pool. So other than these two negative anti-competitive harm, so there has to be a comprehensive evaluation framework. Of course, there is no empirical data to show that, but I think the balance of convenience would lie that the transaction cost savings through these patent pools would outweigh, and in the context of now SEPs and the kind of pools we are discussing, would outweigh the anti-competitive harm. Now, coming to just LNGs quickly, I agree with what Eric has said. So LNGs offer collective bargaining, but collective bargaining for whom? Collective bargaining for, I think, should be limited to only small entities who do not have who have a bargaining power imbalance when it comes to licensing. And yes, Dina Kali has very, very strongly come out and has also basically said that the comfort letter which has been given by the European Commission to this pool, in whatever shape and form is it, without having consulted with American with DOJ and other authorities, she basically has called out, and let's see. So, and the possibility of cartelization, I think, in LNGs is far greater than the possibility of a colluded outcome in the case of patent pools. So I'll stop here.
Thank you, Dr. Malik, for that very elaborate description of patent pools and LNGs, and of course the competition concerns surrounding the two. I mean, I think it's very informative to know about these things because, like I said earlier, these aspects are often neglected. We really don't get this deep into something like patent pool or an LNG for that matter. And you mentioned about Avanci, and I think I'd like to take a minute to actually, request Nishant to talk a little bit about Avanci in the sense of saying that, uh, you know, and I know that, people at Avanci don't like it to be addressed as a patent pool. They prefer the term licensing platform. And we might have our own opinion about the two terms. But the gist of the entire discussion surrounding Avanci is that Avanci pretty much by now has been considered as something that has worked out fairly well. And it is not just limited to the SEP holders saying so. We've seen to a great extent, competition agencies and even judges quite openly advocate for the fact that patent pools do offer a lot of positives when it comes to kind of facilitating the licensing of SEPs. So, despite of all of that, there's one thing that is still that has still not been achieved, and that is a breakthrough in the telecommunication space. The automotive space is absolutely brilliant because we've seen with 4G and then now with 5G, the $32 fee is, Dr. Malik talked about $20 for 4G. The $32 fee for 5G, I believe, is again is not too expensive by any means, because if you look at the utility that the technologies are bringing to a car, to a connected vehicle, so to speak, for that you are paying a one-time fee of $32 for the lifetime of the vehicle. It's absolutely fine. I mean, there cannot be two questions about it. But at the same time, somehow we've not seen that much of a success in the telecom space. uh, what do you think is probably missing here? And do you think there actually is a possibility that we can see a breakthrough in recent time, I mean, in the times to come, going forward? Or is it still okay that we don't have a breakthrough there, but at least in the other domains, considering the extent of IoT going forward, pools are still helping us a lot?
Uh, as regards what's lacking, I think that's for the technology companies to answer that. Maybe there's some lack of meeting of minds. We have seen in at least in the audiovisual space, we have seen companies collaborating, coming together for forming pools, and it has been a very successful model, at least in the audiovisual space. So most of the video technologies you will see are being licensed through pools, and very successfully. So, and at the cost of being repetitive, I'll say that this offers a one-stop shop. It reduces the hassle for the licensees. So I think eventually all companies may have to think and go on the lines of pool licensing, because again, it is about creating less confusion in the market for the final user, in the sense the implementers who are implementing the technology. Our task should be to make it easier for them to take a license, and rather than making it complex so that they don't come forward for licensing. Uh, in terms of again benefits, I'll again uh, bring the experience we have in this in terms of how pools solve this problem and make it easier for the licensees. It is Pal talked about the pro competitive benefits. The transparency problem is being solved largely by the pools. I'll also talk about the essentiality part. So the major question licensees face at times going for a licensing discussion is whether a patent is, whether the portfolio does qualify as essential patents or not. So pools, most of the pools have something called an third party essentiality check, wherein before taking in the patents in their pools, they get these patents evaluated by third party companies or law firms or practitioners. So in a way, you are assured that whatever patents have been included have been tested on the aspect of essentiality. So and since there are a number of patents in the entire portfolio which the pool is offering, you you are in a way sure that okay, I am getting a license on essentially essential patents, and not there's no situation where there is some doubt hanging around on the essentiality part. The other aspect Pal talked about was benefits that SMEs get. So consider an SME which is a licensor. They do not have the resources generally to go into elaborate discussions. Again, we talked about the transactional costs being high in licensing. Uh, they do not have the benefit of having good number of resources, financial as well as personal, to go for elaborate licensing discussions with potential licensees. So SMEs can benefit by joining these pools, wherein the pool is taking care of their work, and they do not have to indulge in heavy licensing discussions, and they just in a way give it to the pool and get the benefits out of it. Apart from that, in as licensees also, pools benefit SMEs, because sometimes pools have these uh, tiered rate structure, wherein a particular volume may be there might be a threshold volume beyond which the licensing rates would apply. So I'll give an example of Via's AVC pool, which has a tier where the sales made under that tier are bear zero royalty. So if the SMEs fall under that range, they don't have to pay anything. So in a way, they are getting the technology, they are licensed, but they are still not paying any royalty. So in that sense, it is always beneficial to have a pool, take a license from a pool, or if you are a potential license, or you join a pool to monetize your technology. So I think these are, I would say, the major advantages that we have observed in terms of pools, and which the other industries can still replicate and maybe think towards forming pools for the larger benefit of the industry as such.
Oh, thank you, Nishant, for throwing some light on that. Moving on, and given the last couple of responses on patent pools and LNGs, I just wanted to know, Eric, whether, given your vast experience of course, having worked with both SEP holders and implementers, and we've talked about this in the past as well, and off camera also we were talking about this. Um, do you think patent pools and LNGs could probably coexist in the era of 5G and IoT, and of course the impending arrival of 6G? And I know very well, of course, given your earlier response, that uh, your opinion with respect to the LNGs is that they should have a limited domain. They cannot be, allowed to operate in the way that an ALNG would operate, because their the utility argument probably would fail, because already there doesn't seem to be an information asymmetry or or a lack of symmetry between the two negotiating parties. But given that, is there a possibility that we see both of these coexisting in the times to come?
Yeah, first, I'd like to thank Dr. Malik for her very detailed and clear answer about the role of pools and license negotiation groups. I think that she added a lot of context to it. I think it's a necessity that license negotiation groups and pools will exist in certain sectors for IoT, just because IoT is this massive concept. It's just everything's going to be connected. And so the number of implementers, the types of implementers, their geographical distribution is going to be enormous. And I think as a practical matter, to be able to reach all of those implementers, there's going to have to be some pooling on the side of SEP holders, and there's going to be needs to be some collective bargaining on the side of the small SMEs in IoT. I think it's a necessity so that it'll work. Nishant's point about pools offering a tiered threshold, so that SMEs get a sort of a royalty-free license, that makes a lot of sense, and that's basically done for practical reasons. There are transactional costs on both sides, and on the SEP holder side, there's no business case for going against a company that makes 10 units or something, or 100 or 1,000 units or something. It's going to pay under $1 a unit. There's no business case for even pursuing a company like that for licensing. But you want them to be within the licensing framework. So it makes sense for them to say, join a pool, and when your volumes pass a certain threshold, then you would be charged for it. So I think that this type of thinking is going to be absolutely an absolute requirement in IoT if IoT is going to fulfill the promises that we hear of so much about. There's a lot of connectivity options for IoT. There's Bluetooth, there's Wi-Fi, there's MIOT, there's LoRa, there's LTE Cat 1, there's narrowband IoT, these LTE-M. And the IoT world hasn't really settled on a preferred connectivity technology just because there's so many options. And I think part of the choice is going to be which ones are easy to license, and that's where the pool comes in. So I think the pools are going to absolutely be a necessity in IoT, and I also think license negotiation groups for the smaller tiers is also an absolute necessity. We're just going about it the wrong way, starting with the automotive companies.
Yeah, thank you, Eric. I think it's a fair point that perhaps it's a start on the wrong footing. The initial thoughts and the initial narrative about LNGs probably has also been to a certain extent influenced by the fact that it has started off with an ALNG, which really doesn't solve the very purpose or justify the ideology behind having an LNG in the first place, like you've rightly pointed out. Okay, so I'd like to kind of step aside a little bit from the two main points of discussion, or the focal points of discussion for today, that is the LNG and patent pool, and kind of focus on the competition side of things, and of course the recent and the much talked about decision of the Supreme Court in the Ericsson CCI case, and of course I would also want to know Nishant's opinion on this, and perhaps Eric, given his association with Ericsson in the past. Dr. Malik, how does how does someone who's kind of well versed with this entire concept of SEPs and the interaction of competition law with SEP licensing and the role of competition/antitrust agencies, and we know that in the US there is not just a single agency, we're looking at multiple agencies, there are a couple of agencies there. How does one view the recent decision of the Supreme Court in the Ericsson CCI case? I mean, do you see, as someone who's been in the thick of things in terms of CCI's functioning in the past, how does this decision firstly be viewed at the CCI? And my second part to the question is it likely to have any long-term impact on how abuse of dominance cases are looked at by the courts in India, or let's say the parties when they are approaching the court or the competition agency if the negotiations don't come to a conclusion?
Yeah, so Manveen, this is a tough one. It started way back in 2013 when the first complaint came to Competition Commission of India, where an injunction by Ericsson on these bunch of OEMs manufacturing cellular phones, Micromax, Intex, Eyeball, Lava, etc., was brought to the CCI because at that time, and this was pre-Huawei ZTE time. So Huawei ZTE, of course, clarified a lot about the process of negotiation, etc. Because so two things. First of all, you have to understand, and the starting point is what is the public law element of which is the competition law is a public law. Why a public law to an essentially private dispute between two contracting parties? So the people who argue for the intervention of competition authorities in these SEP disputes basically stress the need for an arbitrator or a regulator like a competition authority in the negotiation process to see whether or not the process itself was fair, leave alone because I was very clear from 2013. Frankly speaking, I had no background in SEPs, etc. I'm an economist, started reading a lot of stuff. I was very clear, whatever it may be, the problem is of the price. The problem is the rate determination. That is two private parties are not agreeing on what rate to negotiate and what rate to actually strike a deal at. And so in any case, the competition authority is not able to and will not be able to come out with that rate. At best, what a competition authority can do is to see whether or not the SEP holder, which has, of course, a monopoly power, so to speak, though it has been through a lot of ex-ante competition before it's the technology was declared as standard compliant, etc., etc. But SEP holder, okay, let's give that some, there is a monopoly power, and whether or not there is an abuse of dominance in the negotiation process itself. So to that limit, yes, perhaps the competition authority can look at the entire negotiation process. But at the end of it, it is not about only the negotiation process. At the end of it, it is about FRAND determination and royalty determination, which the authorities are not in a position to do. Point number one. The other point, which is also there, we have to look at the facts of the case. Who were these companies? Sorry to say, the companies which were coming to the CCI with these complaints, were they genuine complaints, or were they forum shopping, or were they a way to basically use the technology? As we know, the technology use happens without even getting into a license, that because of the availability of the technology. What was their motivation? And so those are the things, if we look into, without getting into all that, the technology was being rampantly used. There were instances which the court showed that the licensees were unwilling, and then came Huawei ZTE unwilling versus a willing license principle in order to determine whether or not it is anti-competitive. But in 2013 itself, and these are my own personal views, is that we did see all that from whatever it was there in the newspapers and whatever evidence was there before. But having said that, yes, the antitrust authorities were looking at these cases. Competition Commission went ahead. It was then the jurisdiction issue came up. We know about Justice Bakru. He ruled in favor of the application of competition law to SEP disputes. So I guess, whereas there is an inherent tension always between and fault lines between the IP and competition interface, but in the SEP case, I think what courts have tried to do have to not seen how SEPs differ from pure IP. And in that context, so this went through the whole process. So the Justice Bhakru's judgment, that was a single judge judgment, said that it did not rule out the role of competition authorities, and said that SEP related disputes should not just fall under the Patents Act. Competition Act has also got a role to play, which is true for many IP cases, because the reasonability in the licensing has to be seen. But the reasonability of licensing was not under question. What was under question? And so therefore, when I always feel when two cases were clubbed together, that is the Monsanto case and the SEP, I think they are two different cases. And two different cases would require two different kind of an approach, whether what is the role of a competition authority in those set of cases. Of course, it was overruled, and the Delhi High Court, the division bench, basically said that the existence of parallel proceedings under the Patents Act, so there cannot be parallel proceedings, and Patent Act in itself is a act which is self-sufficient. It can deal with anti-competitive conduct, abuse of dominance, etc. So while Justice Bhakru's judgment reinforced the dual regulatory framework of SEPs, the division bench overturned that judgment and took the view that Patents Act is a special law and addresses and is capable of addressing both the rights and limitations of patentees and including the provisions of anti-competitive licensing. Now, when we come to what the Supreme Court has, the recent judgment, so we have to be a little bit careful in reading that judgment, because as of now, it has just dealt with the particular facts of the case. And yes, the law of the land is the division bench judgment, so that holds. But I think the Supreme Court was much more concerned with the fact that all these cases were settled between the warring parties, or between the informants and the opposite parties, that is between the SEP holders and the implementers. So the Supreme Court judgment, in fact, has not an implication about the tensions between IP law and competition. In fact, it has now opened up a new sort of tension, that when parties settle privately, the jurisdiction of CCI is totally ousted, whereas CCI has been till date insisting, and that's of course the essence of that law, that the law operates in rem and not in personam. So therefore, even if two private parties have undertaken settlements, so the question which is now at the center stage is not whether or not SEPs and SEP disputes are under the can come under the antitrust scrutiny or not, but the questions which took center stage at the Supreme Court was that can private settlements close the door to public scrutiny? So if there is, so this has happened in not only in this case, but in another case, that is a JCB matter, again an IP related case, where I think the Supreme Court veered towards the fact that the private settlements do close the door to public scrutiny under competition law, but has left the question open when it comes to question of law. And the Supreme Court also said about the jurisdiction of CCI, or jurisdiction of the competition authority in SEP matters. But that brings us back to the first question, which I am always struggled with, but I think I think it is more of a private dispute and a public law element, which is lacking for a competition authority to have. So this is again my personal views, because the question of law is still open, and the Delhi High Court, of course, judgment holds. So the public law element and hence antitrust intervention may not be warranted in SEP matters, and I'm not saying in all IP matters.
Yeah, I think, thank you so much, Dr. Malik. I think that's a very valid point, because, to a great extent, the importance of this decision and the interpretation is with respect to the fact that how are we looking at the decision in terms of SEP cases and non-SEP cases, yet patent cases. So is there a difference in terms of how, one would tend to interpret this decision? In that light, of course, because we have a few minutes, I just wanted to know whether Nishant would want to comment on this. Maybe a minute, Nishant, and then I can go back to Eric again.
Sure. Maybe I'll just add one more flavor to this, in the sense that I totally agree with Pal what she said, uh, and again, this is my view. What also needs to be evaluated is how the holdout behavior affects the competition amongst the licensees. So I have, say, 100,000 licensees, and they are paying me the royalty for using my SEPs, and they are paying it in time. They took a license without any litigation, and then there is one party which is holding out and not paying that license fee. I have to go to the court, and in the meantime, that party is still not paying anything to me, and my other licensees are asking me, why should I be paying the license fee to you? If there's one party who's holding out, eventually what will happen is you'll go to the court. The court would grant you maybe at best the same royalty rates I took without any litigation. So if I have to, if I have the option of holding out and getting the same sort of royalty fee in the end, and I can evade the paying of royalty fee for, say, another 5 6 years, why not? So it is also affecting, so what needs to be evaluated is whether the holdout behavior is affecting the market as well. The competition in the market, it is, because some of the licensees are bearing that cost. They are building in that cost in their devices, while there's another party which is not paying anything. They're selling their devices at maybe at the same cost, but they are getting more profits because they are not building in the royalty cost. So that's another factor that needs to be looked into whenever such questions come before these authorities.
Of course, of course. That's a very valid point. Eric,
Yep.
as much as you might want to avoid talking on competition, but competition won't leave you. So your final remarks on the matter and in general the aspect of the competition agency getting involved.
Well, I think that Dr. Malik sort of outlined the strange situation we have with SEPs. That I think there's general agreement that the FRAND commitment is a contractual commitment, but a lot of the enforcement action has been done on the basis of competition law. So there's a bit of a mismatch between those two worlds, and they force themselves on each other. And I think we're stuck with that. But we'll continue with that in the future. I think Nishant brought up a very important point about what's the effect on competition for holdouts, because I see that a lot amongst SMEs. Some pay and some don't pay, and on low margin products, that a price advantage of 50 cents is a significant price advantage. It gives you a market advantage you shouldn't otherwise have. I think that's something that the competition authorities need to look at. But of course, excuse me, that's always that's the small scale stuff. It's at the low end of the market, so they don't seem to bother themselves too much about that. But I think it's an issue that needs to be considered going forward. And I think we'll just continue to bump between contract law and competition law, and as we go forward, there's no clearly best way forward. You can't exclude competition law from SEPs. The whole FRAND framework was built with an eye to competition law, but it's recognized as a contractual commitment. So that the two areas of law don't line up with each other, and they don't line up with each other in every country, which makes it even more complicated. So I think we still have a lot of discussions about contract law and competition law and SEPs in the future, unfortunately.
Yeah. Thank you. Thank you so much, Eric. And thank you, Nishant and Dr. Malik, for those highly insightful remarks. And of course, those detailed, discussions regarding patent pools, LNGs, and of course, the competition side of things involving SEP licensing. I think it's been a great 1 hour, personally, for me, and I'm sure for the viewers. Till next time, thank you so much for joining us today, and we look forward to having you in another webinar very soon. Thank you. Have a good evening.
Thank
Thank you.
you. Bye.
Thank
Bye.
you.